Hi, everyone. Welcome to Spyware and Suppression in Human Rights. We are actually all jet-lagged. We just got back from a conference called RightsCon, which is the intersection of technology and human rights. And one of the really big issues that was in this conference was spyware, actually, and Professor Ni Aolain was a speaker on how many panels?
Just one officially.
Okay. That was a really good conversation.
That was a good conversation.
And so we wanted to bring some of this back to everyone here. And yeah, let's get started.
Yeah, so just introduce Professor Ni Aolain. Many of you know her. She holds a dual appointment here at the law school as well as at Queen's University Belfast. She was the Special Rapporteur on Counterterrorism and Human Rights for 2 terms from 2017 to 2023. And in that capacity, in the final months of her mandate, published this report on commercial spyware and its effect on human rights in the counterterrorism context, which was really one of the significant early statements to come out of the UN system on this issue. So she's an expert, and we're really lucky to have her here.
Oh. Does this go? This slide did not update. All right, so this is the basic layout. We have until 1:05. So hopefully we can get to questions, but if not,
Later.
Yes. All right. So just to kick us off, right? What is spyware?
Yeah. So I think a lot of people don't. I mean, how many people in the room know what spyware is? Okay, so a couple of people. That's good. But a lot of people don't know what spyware is. Spyware isn't one thing. It varies, actually. So one of the things to know is that it's a covert product. It's a product that's actually poorly understood by regulators and even by users. Spyware is had both by states, so states own surveillance technology, which is spyware, but so do commercial spyware companies. So there's sort of 2 big markets, a state market and a private company market. The key thing about this technology or this tool is that it gets access to your phone or your mobile device. And it's a non-click access, meaning historically, if you were going to have some kind of malware on your phone or on your computer, you generally would have touched something or opened up something or like done something that would have brought it in. But spyware operates in a way that you won't click anything. You won't even know that it's there. And what it does is that where it's integrated in without your knowledge, is that it accesses absolutely everything on your system. Once your device has an infection, spyware access can record video, access video, and audio. It can access all your texts and communications. It even can do that on so-called secure platforms where you think you have protection from having those communications accessed. It accesses all your contacts. So anybody that you have a relationship with, anybody, is scooped into the information gathering process. And it gives them your calendar, it gives them your geolocation. If you're a lawyer and you have legal documents on your device, it gives access to those documents. And perhaps most importantly for lawyers in particular, it allows for the alteration of documents in a way that you won't know that the documents have been altered. So that has enormous implications for people's security. You can tell where a person is all the time. But also, the integrity of your information is fundamentally compromised when spyware is on your phone or your computer.
So this is commercial spyware, so it's a commercial product. So who's making it, who's selling it, and who's, more importantly, who's buying it and how's it being used?
Yeah, I mean, one of the things that's really hard about this is that there's clearly a market in spyware. And one of the things that we know is that actually states have been very reluctant to say that historically have been very reluctant to say that they're buying this stuff, because the sheer capacity of the instrument and the potential for the instrument to be abused means that we might want to say good states have said they've generally not had this kind of technology. But the truth is that these instruments, these tools are being manufactured in multiple countries. They include the US, the EU, particularly countries like Italy is a current hotspot, China. Israel is one of the key producers of this technology. The UAE is another country that's producing this technology. So those are key countries who are making it. But also we're finding like increasingly subsidiaries opening up in other countries that are kind of ripping off. You know, if you've got a product and you think you can do it in country A, then others. So we've seen kind of subsidiary companies emerge in countries like Serbia using a much less sophisticated version of spyware, but nonetheless seeking to access phones or computers in the same way. And the companies who make this stuff are many. Probably the most well-known of these companies is NSO Group, which is an Israeli company. There's an interesting point, I think, worth noting that the originator of this technology, or some of it at least on the commercial spyware side, seems to have come from Israel. And from, in particular, the use of surveillance technology by the Israeli military, which then moves into the private sector through individuals who left the Israeli military and a particular unit of the Israeli military called Shmone Matayim, which then establishes itself as NSO, but also other spin-offs. So there's a really particular significance to NSO Group, which has also been very visible as the target of human rights activists seeking to identify the use and regulation of spyware. But it would be a mistake to think that the dominant company is NSO Group. They're probably the most well-known group, but this is a flourishing market. And there are many, many companies in this space, of which NSO Group is probably the best known. Yeah.
And their spyware product is Pegasus.
Which
may have
I think we have a picture somewhere of a Pegasus.
There it is. Yeah. So we typically hear of spyware and intelligence gathering through the context of counterterrorism. Right. Why is this an issue in human rights?
Yeah. So, I mean, one thing to say is state arguments for using this kind of technology, and I mean both state-used spyware, of which we know much less about in terms of use and capability, as well as commercial spyware, which we know much more about. States' arguments for using this kind of surveillance technologies, and there are other adjacent technologies to it, but the argument is often a national security argument or a countering crime argument, right? Basically, we need to have, if we think of old-fashioned wiretaps or old-fashioned ways of human intelligence of gathering information, states will make the argument that this is just one more tool in the arsenal of states to gather information that protects us, that keeps us safe from threats, including terrorism threats, but also keeps us safe in our communities by being able to identify criminals, prevent violence, and all of that. That's the argument for spyware. The problem here, of course, is a proportionality and a necessity problem, which is that the scale of information that you get from going into, too many papers, the scale of information that you get from, well, the first question is that use assumes that you're always going to use this technology against someone who is actually a criminal or actually a terrorist. And one of the things that we know, there's an amazing organization called Citizen Lab, which is based out of Canada, and we're going to talk more about the forensics of this kind of technology. But to date, we estimate there are about 12,000 identified cases of the use of spyware technology. And the vast majority of those cases are against journalists, civil society activists, politicians, dissidents, people who disagree with their governments, students. So one of the reasons it matters for human rights purposes is the stated argument for use is a security argument, but the actual basis of use appears to be those who are oppositional to their governments, those whom their governments perceive, rightly or wrongly, as a threat to their power, not a harm to people. And so that obviously raises a question of human rights. But related to that, of course, is the kind of scale of what happens when you get into somebody's phone or computer. So for most of us, our lives are on if you get somebody's phone, you're going to know everything about that person. You're going to know their religious inclinations, their sexual preferences, their health information, where they go, who they hang out with, and all kinds of things about everybody that they're associated with, which is scalar. So from a human rights perspective, what that raises is the idea that you could access a person's entire life without cause. And we think of the right that most obviously comes to mind here is the right to privacy, that every human being, inherent in our human dignity, is a core of privacy, that there are things the state should not know about us, that is just our business. And so the most obvious right that's implicated here, why it matters from a human rights perspective, is privacy. But maybe it's important to say that privacy is not a luxury right in the digital age. So we might have said 100 years ago, the capacity for us to be knowable to the state was actually quite limited. But now it's actually absolute. The state's capacity to know us through the devices we all carry is absolute. So in that view, privacy isn't a luxury right. It's not and there are really big questions about what the status of privacy ought to be in the digital age. Should we think about it the way we've historically thought about other rights that we've said are absolute? And maybe the final thing to say is that, as we'll see, I think there's a picture of Jamal Khashoggi here behind me. How many people know who Jamal Khashoggi is? Okay, that's really good. Well, you know that he was hacked to death and cut into tiny pieces in an embassy in Turkey. His body has yet to be found. He had gone to that embassy with his fiancée, actually, to get papers in order to facilitate his marriage. But he'd been tracked there through his phone using Pegasus technology, and there were a group of people from the Kingdom of Saudi Arabia waiting to kill him. And the reason they knew he was there was because they had been tracking him through his phone with Pegasus. So when we talk about Jamal Khashoggi, becomes this kind of symbol of what the sort of link between privacy and other absolute rights is. Because if people know where you are, who seek to do harm to you at any given moment of the day, then your right to life is expendable. Then your right not to be detained without cause is expendable. Then your right to all kinds of things is simply taken away. So the point about the rights piece here, as Shane has asked, is that, yeah, the implicated right is privacy, but privacy in this space is the gatekeeper for all of your other rights. And so that's why this technology is so dangerous, because its use implicates the absolute violation of every other one of your fundamental human rights. Yeah.
Part of the Khashoggi case is that one of his colleagues who was in Canada was surveilled by the Saudi government from Saudi Arabia, and they uncovered his communications with Khashoggi in Turkey. And so this is fundamentally an international, transnational issue. Yeah. And so when we think about international law and kind of the legal structures that are available to addressing what's clearly a huge issue, kind of what are the structures we're working in and what are the options?
I mean, part of the challenge we're facing, and this was certainly when I was in the UN, part of the challenge is there's no legal framework for there's no global regulatory framework for spyware, none, zero. And it feels to me a lot, actually I think when I started the work on spyware, it felt to me like we were back in the early 2000s when drone technology first appeared on the horizon, and only a handful of states had drones. And they were expensive to build, they were technologically quite They were super advanced, but they had limited reach, right? And at the time, there were a group of human rights actors pushing for regulation of drones. We were saying, this is a new form of technology that doesn't quite fit in within the Conventional Weapons Treaty. It doesn't really fit within national frameworks of regulation, and we need a treaty on drones. Well, the states who had it didn't want to be restrained, and the states who didn't have it wanted it. So the result is we didn't end up with any regulation on drones. And I don't know how many of you are closely watching the Ukraine conflict, but this is a conflict now mostly being waged by drone warfare. So we sort of missed our window to do regulation on drones. And so we're in a similar place with spyware technology. In the last decade, many states were simply not acknowledging they had it, right? So it was sort of like Voldemort. You couldn't say it. You don't say you have spyware, because good states don't use that stuff, right? But now it's increasingly clear that lots of states have this stuff, and more importantly, lots of democracies have this stuff. So a couple of years ago in Europe, a committee of the European Union was established because it was identified through really amazing journalistic work and some good forensic work that two countries, Spain and Poland, had purchased and were using spyware technology, not against terrorists, not against criminals, but against the lawful opposition of their countries, to stop them from engaging in politics, essentially, or to allow the state to know what they were doing. And that spawned a kind of crisis in Europe, where it was clear that these democratic states who don't have a lawful basis to spy on the lawful opposition had purchased this technology and were using it without any kind of restraint. So that gave rise to something called the PEGA Committee, which is a European investigatory mechanism under the European Parliament. And one of the things that committee said is, we just don't have a good model here for regulating spyware. So what are our options? Well, we have a couple of options as they currently exist in international law. One is called dual-use regulation. So this is basically an export control model of regulation. We do this already for lots of things, like mostly weapons, but not only. And that dual-use framework is really about saying there are certain kinds of goods that cannot come into a country, or in this case, or the European Union, without being regulated. Either they're banned or their use is limited. So spyware currently is not included in dual-use regulation, and one of the big moves right now that I and others are trying to do is to shift it into dual-use regulation. So that at least would be one place where you could say it limits what countries can bring in and how much use they can make of these technologies. And if they use it, it has to come with certain restraints on use once it's in the territory. The second model is a treaty. Well, in an ideal world, we would have a treaty on spyware, but we don't. And I think it's increasingly unlikely. And part of that is because we have a rogue state called the United States at play in the moment, which has very little interest in strengthening international law. And I think, given that we believe that the largest users of this technology are countries like Russia and China, it would seem unlikely at this point that the US is going to pursue a treaty or give support to a treaty. And those powerful countries are not likely to want a treaty either. So that would be another route, would be a treaty. A third model is through human rights law, where we try to identify state use of spyware and then hold states accountable for the human rights violations that follow from that. And as we'll talk about in a little bit when we talk about forensic, that's a really good theoretical way to think about it. But one of the things that's really hard is identifying spyware, like figuring out if you have it, and how can you protect victims if they come forward, and how can you prove the use of the device. So theoretically, human rights law, treaty bodies reporting, individual cases at international courts, this might be a route to do some spyware regulation, but it's pretty nascent. And the fourth and final model is the model that my report proposes, which is really a model that no state has accepted yet. So to be clear, there isn't like a whole bunch of people running out to do this. But the model that I and my legal team, Adriana Erdemus-Jones, who's one of our fellows here at the Human Rights Center, proposed is a liability-based model. It's essentially a capabilities model. And my view is that you actually have to regulate the design. It's not just that you have to regulate use, you have to regulate design of spyware. You have to start with the manufacturers, and you have to have some fundamental red lines. So for example, one fundamental red line on spyware is non-editability, meaning if states can argue that they should be able to see things on your phone for good reason, then they shouldn't be allowed to alter anything on your phone. That's a red line, that alterability. The second is record. If a state accesses your phone through the use of commercial spyware, we have to be able to demonstrate that they were there, right? So this model, a capabilities model, is the one that my UN mandate has been pushing. But it turns out that there's not a lot of appetite for states to regulate. And right now, the single largest challenge we're facing is that states have very little interest in either hard or soft law regulation. And it's just worth noting for the folks who do business and human rights in the room that there are models of soft law here. So all of the things producing the spyware, commercial spyware, are companies. So theoretically, we could hold them to the standards that we've built, guidelines for business and human rights. And I think, to be honest, that's what the companies want. NSO Group has been arguing for soft law regulation. And so I think my general view is that's like a bad idea, but that is a model that's out there. So, yeah.
So what is currently being done about spyware? You mentioned forensics. You mentioned the putting forward these models. What's happening in the space?
Yeah. So when we were in Taipei last week, one of the things that's great about this conference, and students who may be thinking about a career in tech might want to check out this conference at another point, is that it wasn't just there were lots of human rights people there, but there were lots of tech people there. Tech people for good. And a lot of the folks, the tech folks in this space are really, there's been a significant investment in forensic capacity. And the two leading labs for that are this lab called Citizen Lab based in Canada, which works out of a university. And the other is Amnesty Tech Lab based in Berlin. And so here you have a group of technologists who are human rights activists, actually, that's maybe the best way to describe them, who have developed ways of actually testing our phones. I get my phone tested regularly because I do a lot of work that makes me nervous about who might be interested in what's on my phone. And so they run a forensic diagnostic on your phone to figure out if your phone has been, if there's been any trace of spyware on your phone. Now, one thing to note is, those of you who have Apple phones, it's actually much easier to run the diagnostics on an Apple phone than it is on an Android. Really much harder. Android space is a much more difficult space right now to identify misuse. And the problem that means for human rights activists is that in many countries, human rights activists can't afford an iPhone. And so there's a huge investment in these labs. And I should also say one of the key things right now is trying to spread that forensic capacity out of the global north into the global majority. Because most of the places where this is being used is not, I mean, I've talked about Poland and Spain, but actually the places I'm most concerned about are countries like El Salvador, countries like Guatemala, countries like Brazil and Colombia and Latin America, countries that have historically and increasingly either repressive or authoritarian regimes. These are the countries where people are most at risk. So there's a big push, to Shane's question, about building this forensic capacity in the global majority. But it's hard. And bear in mind, the techies are just a half step ahead of the companies. Because the companies, every time you figure out how to fix a vulnerability, the companies are in there trying to figure out the next exploit. So it's a really complicated sort of cat and mouse game. So that's one piece of work that's really important. Second piece of work is litigation. And so there's a lot of litigation happening right now. And I will say a couple of things. Some of that litigation, I shouldn't say, a lot of litigation happening in a couple of companies and countries. And the US is one, and the UK is another. And I won't say much for now, but just to say there are a ton of barriers to that kind of litigation. It's really difficult to do that kind of litigation. And the strategy that these companies have used is they have powerful capacities, and you have small NGOs or others taking cases, right? So the kind of equality of arms in litigation here is not equal. And so I think that's the second place where we see action. The third is just in this sort of space around regulation, trying to move a conversation forward about regulation, like trying to talk about treaty, soft law, and other processes. And maybe the last thing to say is that there's a huge amount of, like, the number of you who've showed up today is really encouraging, because lots of people aren't thinking about the impact of tech on rights. And part of this work is really about engaging civil society, not just that you should be aware of the dangers of your own phone. That's hugely important. But to understand that spyware is an existential threat. It may be an existential threat to democracy. Because if you have authoritarian or backsliding regimes that use the coercive power of the state allied with tech to clamp down on those who disagree with them, you don't have democracies anymore. You have the capacity to eradicate protest, to undermine people's ability to engage in public space, to compromise individuals in ways that makes it impossible for them to be public participatory citizens. So a lot of this work is also work with civil society to make civil society and ordinary humans care about the use of commercial spyware. Yeah.
Could you put that a bit in the context of like a broader shrinking civic space? We skipped over this slide earlier, but
yeah.
Kind of in the larger context, in the human rights and counterterrorism intersection, how this fits in.
Yeah, I mean, sorry, we're jumping slides. I'm not being linear, but these are good pictures. Yeah. I mean, one of the things that I had a huge interest in tech as special rapporteur, but one of the other key places of my work was on civic space and civil society. And civic space is shrinking around the globe. It's shrinking because of old-fashioned methods of harassment, intimidation, and oppression. Locking people up is a good way to keep people from protesting. Regulation is often a way to keep civil society from functioning. So you can tie, it's a little bit like the strategy that was used in the United States against abortion clinics. If you create 1,000 regulations for a clinic to work, then it's hard to keep that clinic open. We see that kind of model of death by administrative law, actually, is a really big motif for civil society. But the third leg of that is technology, is spyware. So even in countries where there isn't enough forensics to figure out if everyone has been targeted, people are afraid of it. They understand the dangers of it on their phone. So when we were in Taipei last week, Citizen Lab had their booth, and like there's people lining up day and night, and these are civil society folks from across the world, to get their phones checked, because they don't have that capacity at home, and they understand their vulnerability to state intrusion if their phone's been infiltrated. And what happens is that people self-censor. I mean, that's what happens. Civil society becomes afraid. People decide that they are not going to engage because they're anticipatorily afraid of the state's surveillance of them. But not just them. Because if somebody gets your phone and you have kids, and they have information about your kids, or you have an elderly mom who's not well, or you have a brother who's gay, or a sister who's got a massive amount of debt, and there's all of that information on your phone, it's not just that you're vulnerable, they're all vulnerable because the state now has a set of information about you and your family that makes you much more vulnerable if you decide to criticize your government. So this shrinkage of civil space is just profound, and the mandate issued a global study on the impact of counterterrorism on civic space, supported by the Human Rights Center here at Minnesota. We traveled the globe for a year, and we measured like both in terms of empirical data, but also anecdotal evidence and narratives about the fear that people are feeling. And of course, I think that fear is also here in the United States. I think we should all be afraid when we have a president and an administration that talks about vengeance, that talks about targeting people who disagree with them in different ways with the coercive power of the state, whether that's taxation or other methods, or will fire people from their positions if they disagree with them. So all of that has a chilling effect. And they're using the tools of security to do this work against civil society. That's the intersection. And it's a really dangerous one.
Oh. Kind of out of every dystopia you can think of. So jumping back, I know we're going a little out of order, but such is life. So there are different conversations happening, and the Palm Mall slide is next.
Yeah.
But can you tell us more about what those conversations are?
Sure. So I go back to saying, we're in this space where we don't have any overarching regulation on this technology. And we have a group of very powerful companies, but also state interests. So one of the things for human rights actors is we've had to make some really strategic decisions. And one strategic decision is, do we address the totality of surveillance? Because states have this technology. And again, our understanding and comprehension of the scale of its use remains actually pretty limited. Or do we focus in on a much narrower set of regulatory possibilities, which is the role of commercial spyware? These companies who operate, many of them are publicly listed, many of them are known. And so I think we've seen this quite deliberate decision by civil society and this sort of intersection of the tech companies and the tech companies, the sort of forensic capacity folks and human rights activists to focus in on commercial spyware. Why? Because it's identifiable. 2, because we think there are ways in which they could be regulated. And 3, because actually they're visible, right? You could like think of the story on Jamal Khashoggi that sort of struck with people. It's much easier to do that kind of that work of building a consensus that something is needed. But this regulation story has sort of had a long trajectory, because when civil society actors started off talking about spyware a decade ago, they were really talking about banning it. And what they were saying is this technology is not capable of being human rights compliant. It's inconsistent with fundamental human rights norms. This idea that you can attach to all of that kinds of information in a person's life, that's just fundamentally beyond the scope of the power that the state should have. And early on, we had a group of civil society actors arguing for banning it, just banning it. And the problem was that no state signed on. Surprise. No state wanted to ban spyware. So then we had a group led by the High Commissioner for Human Rights at the time, and David Kaye, who was the former Special Rapporteur on Freedom of Expression, who was on our panel that the University of Minnesota Human Rights Center ran last week in Taipei. And their position was moratorium. Let's just pause this technology until we can figure out how to regulate it. And for a brief point, we had a couple of states who were up for a moratorium, led by Costa Rica. Costa Rica, a couple of years ago, came out and said, yeah, we're behind a moratorium, and they got 10 states to sign a statement. But nobody else has signed on, and Costa Rica has also pulled back from that position. And so now we're in a sort of an odd place where actually our only choice is regulation. There's absolutely no state appetite to ban it. Nobody wants to stop it. And there's no capacity to stop in the midterm. And so we're now in this space of regulate. And the challenge here is that we're in danger of having very permissive regulation. We've moved from a conversation about can we use it at all to let's see how much we can use it. And that's the kind of complexity of the space that we're in. Which brings us to Pall Mall.
We've got just about 10 minutes left, so maybe we can move to Q&A. If there are questions, we could and we have talked about this for hours and hours.
Yeah.
But any questions in the room? Yeah.
I'll take them there.
What does someone do, like, once they discover, like, there has been spyware on their phone? Like, are they able to determine, like, put that there, and, like, what kind of the steps after that?
So that's a really good question. The answer is, I've interviewed spyware victims during the course of my work, and so a couple of things. Depends on the forensics. Sometimes the forensics will be very helpful, but be very exploitative in the sense that they will be able to identify that, for example, it's a Pegasus intrusion, that there's been some kind of intrusion, that they can identify who's a company or who's the agent that's done the intrusion. Sometimes not. And I think the not is you can identify that there's been an intrusion, but the forensics are such that you can't really tell. There's no identification of source, right? And some of that may well be that the intrusion may be a state intrusion for which we don't yet have forensics that can identify accurately. So that's a huge, I want to say, black hole. You can have your phone identified, you can identify more or less the commercial spyware intrusions are identifiable, at least on an iPhone, but the state intrusions, it's kind of a black hole. So then let's assume you have an identified use, and then you go to the victim and you ask, do you want this to be made public? And sometimes victims do, but also sometimes victims don't at all want it to be made public. What they want to do is get rid of their iPhone, and they want to figure out what might have, like, take some precautions to kind of prevent harm to them, but they don't want to be made further, they don't want to be public. Because their fear is, again, depending on what country you're in, that saying that you've had an intrusion will make them a further target of state harm. So that's a huge problem, is this gap between identification and victim willingness for good reason to do anything else. And anything else could be publicity. Another option is litigation, and maybe just to say one of the challenges here is that it's extremely difficult. So let's assume you have an intrusion on your phone in Kazakhstan. First of all, you may have no cause of action in your domestic courts. And second of all, your capacity to marshal the kind of evidence and use it in that court may not be available to you. It may be too costly, or even the evidential rules of admissibility in court may make it very difficult for you to adduce evidence that there's been a spyware breach on your phone. And then, to be honest, one of the big challenges is the target of litigation. So obviously, if there's been a breach on your phone, you may be able to identify the company, but your working assumption is who's doing it? Who wants your phone information? It's the state, right? But as a litigant, you may have zero access to the information that identifies a relationship between the spyware company and the state. So proving causality is really difficult in these cases. And it's worth noting that the only place where we've had really successful litigation is when one of the companies, so the WhatsApp case is a good example of a case taken by a technology company against NSO Group. And there, because the technology company has both the resources but also the evidential requirements here, were not about harm to an individual, but the use of the kind of platform, the evidence, it was still hard, but it was easier to prove the liability. And so I think that those examples just illustrate that even if you find it, remedy is really elusive in this space. Yeah.
And that What's Up case was in the Northern District of California, and it was just decided in December of last year for those interested.
What preventative measures can we take in our personal lives to avoid this problem?
Yeah. Yeah, so I mean, I think for those of you who end up being human rights activists or at a target, then I think you'll probably find ways to get forensics done on your phone to make sure that your phone hasn't been affected. The other thing I would say is we have some swag today. We came with swag.
Yes.
In fact, Shane came with swag from Taipei. And so there are some simple devices, like making sure that all your software is up to date, that you're downloading and making sure that you're using, who's doing that, right? But that's really important. That's your first, like good tech hygiene is like brushing your teeth. All of you should be doing good tech hygiene on your phones, on your computers, keeping your programs up to date, making sure that you have guardrails against intrusion. The other thing we're giving out, well, there's one example of this, but this is the cut the camera. How many of you have a camera, a device over the camera on your computers?
A few.
A few. I would recommend everyone get one of these. And again, that's a small, it protects you from having the camera in your computer used against you. These are small actions you can take. But the other is, whether you're a human rights activist or just a technologist, you should be interested in having this stuff regulated. This regulation is absolutely essential to prevent abuse. And so regulation would help all of us.
See how it benefit, but what incentive does a state have to regulate its own? If it's possible in the international arena, like how would you hold states accountable for not performing?
Yeah, so it's a really good question. It's why would states choose to regulate here? And actually, we have really good examples of that. So 2 years ago, President Biden issued 2 executive orders on spyware. I would put a bet that they're about to be rescinded. But President Biden's 2 executive orders prohibited the use of domestic spyware by domestic agencies in the United States. And it's not because he woke up and was like a human rights advocate on spyware. It's because he and the National Security Council recognized that the ubiquity of this technology means that US citizens are at risk and targets from other countries and other actors. So the incentive here isn't because states don't want to spy on their own citizens. Sure, there are many states who want to do that. But in particular for democracies, actually, the risks are now about the use of this technology against them, against their politicians, against judges, against lawyers, against journalists, not domestically. So that's the incentive here. And the Pall Mall process, which is a process that is sort of a soft law process that's was led by France, the UK, and the US. Part of the incentive for states in this process is their fear that the sort of it's like drones. We started off with it being a tool that only a handful of states had and nobody else. And now we're in a universe where every state can have it, but more importantly, non-state actors can have it too. So I think the incentives to compliance here for states or the incentives to a global system are not because they woke up and they love privacy, but because they have an understanding that these tools are going to be used against their political and economic systems. And that's what's going to drive regulation. Yeah.
Okay. Thank you so much for joining us today, both Professor Ni Aolain and all of you. Thank you so much for being here. Really great questions. And now you have to run off to vote.
I have to vote at a faculty meeting, but I want to thank Shane and Micah who came with me to Taipei. I encourage you all to take a look at RightsCon and look online and see it, because it's a huge and amazing conference, both for folks interested in tech, but also folks interested in human rights. And the other thing is there's a ton of swag up here, like great swag. So please come and take some and stick it on your computer, look up the websites and enjoy. So thank you all. Thanks to both societies.